Good evening, this is John Milburn. This is Laws 12062, Alternative Dispute Resolution. We're into week 5. I must confess I really haven't followed the script this year, but you can look at what I did last year on YouTube as an idea of how I went by week. But this year I wanted really to create an emphasis where for the first half of the course we're talking about assignment 1, what's needed for that. And in the second half, we'll talk about assignment 2. So we've got a few weeks yet before assignment 1 is due. I suspect that those of you who are joining me live have already started your assessment. Those of you that are watching the recording, if you haven't already done so, please start. You should have your group organised. You should have your scenario worked out. You should certainly have learnt the technology by now, probably done a trial run, and start to think about the actual procedures. Now you do know, and I think from week 1 I've told you, good luck in trying to get an extension from me. It's going to be very difficult. You can always submit your paper late, but you will lose 5% per day. And I have a cut-off 9 days after the submission is due. After 9 days you get 0. We don't want that. So please make sure that you're ready to go, and you can record as many as you like and just submit the best one that you like. So you can do a trial run now, have it up your sleeve so that if everything goes badly, you can always submit the first one you did. There's no problem with that. The only stipulation is that you do this as a continuous run so that it's not 5 minutes and then stop and regroup and re-edit. I want to see a continuous process. So if you get 13 minutes into it and you do something terrible, scrap it and start again. Sorry. Okay, last week I set an exercise for everyone, and what I propose to do is share the screen now so that we can look at what I called a practical skills exercise. So hopefully you're now seeing my other screen, which has practical skills exercise up on the screen. Please let me know if that's too small to read. Can you see that? I'm getting a few nods, yes. All right, so in ADR, we encourage people to take ownership of their own dispute. Now, that's not just some theoretical statement. It's something that I want you to apply, and the purpose of this exercise is to have you do that. Now, lawyers find it difficult because we control the process. We're at home when we're in court, when we're talking about the applicants or the plaintiffs or the respondents or the defendants, and we're the show in that sense. Now in ADR, particularly in a mediation or a conciliation, the reverse applies. And the clients, the customers, the punters, the participants, the antagonists, whatever you want to call them, they're the ones that control the process in the sense that it's their dispute. Now, in a very real sense, the way where we see that happen is that the nomenclature changes. The way in which we describe people changes. So in court, a person might be the applicant, but during a mediation session, it's Mr. or Mrs. Smith, or it might be Bill or Jane. So bear in mind that very quickly and accurately as an ADR practitioner, you need to identify the names and relationships of people involved, and you need to prepare for that. You need to have something ready to go. Can I tell you this? If in your mediation session you stall the negotiation process by asking something that is very basic, like such as, now tell me again your relationship with this person is what? Just at a time when the parties are starting to gear up and talk to each other, and as a result of that you start to lose the confidence of the parties, then you will be marked down severely. So the point is, prepare and be ready to talk to the parties on their terms, not the terms that we're accustomed to doing in a court session. I use a genogram. Now, I'm not sure if this is the way I use it is strictly in accordance with the proper principles of genealogy, and someone who knows something about genealogy will quickly strike me down. But it's just something that I've adapted for my own use. So you'll see there that there's a little flowchart, and it gives you an idea of the relationships between the parties. Now, you can do this sort of thing for a chronology or for a list of the parties, and you can certainly be very creative. Now, at its very basic level, in a mediation or conciliation session, I would recommend that you have the names of the parties in front of you and I'll just stop the share for the moment, and I'll come back to that screen. So what I'd recommend is that you have the names of the parties physically written down in front of you as it coincides with the names of the participants. Now, in the exercise that you've got, it'll be pretty easy because you've only got 2 parties. But bear in mind that what you're training to do is potentially be in control of a room where there may be 8 parties or 10 parties or whatever it might be. So one thing that I do is physically write down the name of the party in a direct line with the party in the room so that I can glance down at the paper and pick up and remind myself, yes, that's Jill. So that's one thing that you do actually in the mediation session. But then you have to remember the relationships between the parties. You have to remember how Jill is somehow associated in this dispute with Bob, who's sitting over here. And you need to understand the dynamics of it. We'll just go back to that share screen. And that's why I use the little flow chart as well. So you'll see here, that's a flow chart from the movie Love Actually. I take it some people have seen that, if not all of you. But you recall it's sort of like a complex web of interrelationships between various people. And that's a flow chart that just shows the relationship chart between those characters in Love Actually, the movie. So here's the exercise.
Sorry, John.
Yes.
I think you may be displaying the wrong screen. I can only see a Word document.
Okay. So at the moment, can you see my cursor with a flowchart? No? All right. Let me stop the share. So
your desktop and a Word document.
Right. Okay. I'll try again. Thank you. Was it the same before? Did I have the wrong document up before? No. Okay.
It had the right document before.
Okay. I'll try again. Now we're right? Is that the correct one? And thanks for reminding me. I'm sorry. I pushed the wrong screen. It's wonderful having 2 screens, but you've got to make sure you get the right one. So there we have the flowchart for Love Actually and a whole range of different people that are involved or characters in that movie. So the exercise that I gave you relates to Jim Brown, and the task is to create a little flowchart that works for you so that if you're in an ADR session and you're dealing with these people and they're talking about different characters, you can very quickly and seamlessly identify who we're talking about and how they're related to other characters. Now, I'm going to be a nuisance here and propose that I give you 5 minutes to look at that and create your flowchart. If you've already created your flowchart, feel free to leave and go and make yourself a cup of tea. But I'll come back in 5 minutes. Now, just with a nod or an exclamation, you can see the script there. It's broken over 2 pages. That's a yes? All right. Okay, so I'll leave you to work on that flowchart and I'll be back in 5 minutes. For those of you that are watching a recorded version of this session, please also do so because soon we have to answer some questions. Don't worry, they're pretty simple. We'll see you in 5 minutes. How are we going? Another minute? Is that you're finished, Peter? No, not yet. All right, another minute.
What a web.
Sorry. How are we going? We're getting close?
Yeah, nearly there.
All right.
It's running out of room on pages as I'm expanding.
Okay. Thanks, Peter. All right. Well, we might call it quits at that. And what I'm going to do is I'll stop the share now. My apologies for those that haven't quite finished. Because what I want to do is have you put yourself now in a mediation complex. So I've said you act for Jim Brown. So whether you're the mediator or whether you're there as a solicitor in the dispute, this is the sort of thing that you hear, and your task is to follow it and understand it in real time. Okay, so during the course of the mediation, you learn, and what I want you to do here is have a look at your own notes and see if you can follow it. You learn that Danny has started seeing Mary, but he could not bring himself to tell JB. Sue is very upset at this latest development, and she phones Donald to voice their approval. Were you able to follow that? I'll just go to gallery view for a minute. Any thumbs up? Now, just did it help having the flowchart there? For me, it does, because if I was confronted with that sort of scenario and I was looking at the paragraph, I kind of get lost in the text. But having the flowchart means I can follow it and go, okay, I'm with you, I follow the situation. All right, we're ready for the next one, and there's 3 of these. In the meantime, Jack and Derek, who are kickboxing enthusiasts, decide to take action, and they encourage Tommy to confront Betty. Of course, Tommy has reservations, and Jill encourages Jack because she has mother-daughter issues. Again, how did we go with that? Could you follow that? You could see what was going on? Good, thank you for the thumbs up there, Molly. All right, any problems with that? Anyone not follow it? And Josh has joined us, thank you. All right, we'll go on to the third and final one. So again, looking at your flow chart. Through Cody, Ricky knows Michael, and Ricky tells Michael what he heard Doris say about Donald. Okay, we got that one? All right. No? Trouble with that one, Michelle? How did we go otherwise? Michelle, do you wish to make any comment about that? Was that tricky? No audio there, Michelle.
Can you hear me?
Yes.
Okay, cool. I couldn't find Ricky on my map, but then I did. He's the other teacher.
Okay.
I'm on it. I just wasn't quick enough.
and it's a real art to create a little flow chart that makes sense to you. And that's all it has to do, make sense to you. All right, so any questions or comments about that exercise? And thank you for participating in it. All right. Now, in the context of the first exercise, I'm sorry I keep talking about this first exercise, but the skills that that are in your textbook and your notes in relation to negotiation, mediation, and conciliation are all, of course, relevant. All of this is within the context of ADR. Now, when you're in the hot seat, when you're the mediator or the conciliator, you need to plan for the very real contingency that you're hit by a wave, which is, I don't know where to go. There's nothing coming to me. Now, bear in mind, as I said, Judge King, District Court Judge, described the process as remaining light on your feet. It's a bit like it's a boxing match. You've got to be able to move, dodge, weave, counterpunch, whatever, all in a nice way as a mediator or conciliator. So you need to have a few things in your toolbox that will assist you if you're really stuck. And one way to do it is to go back to some of the old chestnuts, to go back to some of the basics. And if you think about why people should consider ADR instead of litigation, then you'll come up with some ideas that might help you. So ADR is efficient and it's quick and it's cheap resolution of disputes. Okay? So just a basic statement. But if you have that written down in front of you, it just gives you maybe a few words as to why we're here in the first place that will get you started again. So you look down and you see the word quick, you think, okay, I can talk about that. And it might give you an opening. And the opening, a lot of these opening questions are who, how, where, what, when, why type questions. So if you're really stuck and you think, I don't know what to say, you see the word quick, you quickly translate that into a question. And it might be something like, how would you feel if this matter drags out for a lengthy period of time? So you're away again. It's another topic of conversation. And you can bounce around during these things. It's quick. You see the word quick written down. Just in your toolbox, just the word quick only means something to you. And you think about how you might frame that into a question. And it might be, what alternative have you thought about in terms of resolving this? If we don't do this quickly, how's that going to make you feel? Whatever it might be. So have some of these things ready to go so that you can ask yourself some questions. I'll just give you a few more things that you might want to consider writing down as to why people who are involved in litigation may consider alternative dispute resolution instead. And one of those is that the court system is relatively slow and expensive. In litigation, the decision process is taken away from the parties. So if you write that down, it gives you an opportunity to say something like, you understand in this ADR process, we control the process, it's your dispute, and we're not bound by rigid rules that lead to a specific result. We can think about alternatives that come from left field, to use that Americanism, sorry, but provide options or generate options that wouldn't be available for a decision maker to consider in coming to a resolution of a dispute through litigation. You might also say that ownership of the dispute is important. It's your dispute, it gives you a chance, and it provides an extremely wide range of options that might be available to you. All right. In terms of, just looking at some notes that I've prepared for myself. Okay, in your textbook, you would have seen some commentary in relation to conflict. And when you read these notes, I want you to read it critically in this sense. Read it as if you are a mediator or a conciliator, asking yourself, how am I going to use this information as a means of resolving a dispute? So it's really the same point that I made before. Maybe some words that you write down that will help you to better connect with the parties and kickstart the negotiations. So conflict, says Spencer, is often characterised by tension and poor communication. If you write that phrase down, how could you use that, do you think, in a positive way when dealing with the participants? Are there any thoughts?
John, would you just repeat that, please?
Yep. So the phrase is, conflict is often characterised by tension and poor communication. You've written that down. It's part of your toolkit. How do you use that to encourage the parties to resolve the dispute?
Would you try to reduce the tension somehow?
Excellent, Gordon. Yes. I think sometimes if you acknowledge that there is tension and you make it clear to the parties that you know that it's a tense situation and you accept that and you acknowledge it, that in itself is a way of resolving the tension. People can say, okay, yep, he or she understands. And the other side says that as well. So thank you.
Could it also be that first step where you get them to tell their side of the story as a kind of a catharsis?
Exactly, yes. And in the opening statement, it's important that people have an opportunity to tell their story, subject to the rules and the boundaries that you set up. But it is cathartic to be able to just say something in a controlled environment. And it does ease the tension when people can start to say things. Thank you, Gordon. Josh says, rephrase what has been said to improve communication. So rephrase or reframing is always an excellent way to deal with those situations. Okay, so we understand that conflict is often characterised by miscommunication. How can we use that word, miscommunication, in a positive sense when dealing with the parties? What's a phrase or a question or a statement or something that you can say to the parties that acknowledges that and creates it into a positive? Don't worry, I'm not nominating people tonight. All right, so if we were to say, for example, something very basic, you know, in my experience, many disputes are created through miscommunication. So part of the dispute resolution process is for us to clear the channels of communication so that at least we have a chance to say exactly what we mean and be heard and understood. Now that goes for both of you. So it's important that you listen carefully and actively while the other person is speaking. Don't interrupt. And from that, we'll see if we can ensure that at least you understand what the other side is saying, even if you don't agree with what they say. So that's kind of a, you know, a statement that you might make to the parties to both acknowledge that conflict is sometimes caused by miscommunication and that you're there to help solve that problem by ensuring that we have appropriate and accurate communication. And so there's a whole range of things that Spencer has in his textbook. And when it comes to you creating your little toolkit that you can use for mediation purposes, think about the words, think about the phrases, and ask yourself, how can I use that information now to be a better dispute resolution practitioner? And I'll just give you a list of the words that I've written down that I've drawn from Spencer's text. So miscommunication, lack of information, power imbalance, language difficulties. Now, there's some of the words that I've put down under the heading of tension and poor communication. So if you acknowledge that there is a difficulty with language or maybe capacity issues, mental health, reduced cognitive functioning, by acknowledging it, you're some way towards resolving the dispute. Okay, it's not just an issue of communication. Sometimes in conflict, it's acknowledging the way that people react. And some of the words that I've used, that I've made a note of, are these, that in times of conflict, people act in different ways. They might act through emotion, avoidance, anger, distrust, fear, failure to listen. A whole range of words. There's a whole lot more. But the idea of writing these words down, or at least identifying the words, is so that you can then use that to your advantage. Okay. Now, what if you have a situation where in a mediation, you detect that one party is just not listening or not listening carefully? They're not actively listening. How do you deal with that situation and try to encourage that particular party to actually listen without being rude, without alienating them? How do you do it? Any thoughts?
Perhaps draw their attention by asking them a direct question.
Yeah, I think that's a good idea. Thank you, Molly. Any other thoughts? Someone's not... Yes, Peter?
Could you ask them if they're in agreement with the other person that you're mediating with?
That's a great way to do it. And even if you expect that they'll say, I don't agree with everything, remember that picture of the mediator with the two dogs? And the mediator saying, first, can we agree that it's a big backyard? So try and get some point of agreement, and it gets them listening and nodding. And once they start to listen and nod, it then can create some momentum into the next area. Are there any other techniques that you can use when one party is just not listening?
Could you do some one-on-one with that person?
Yeah, there's, I think, always a place for one-on-one. One-on-one can take place during the intake, but you've got to be careful. But more particularly, a one-on-one will happen in private session. and it might form some gentle counselling during a private session. Bear in mind, of course, that if you have a private session with one party, you should always attempt to have a private session roughly at the same time with the other party. There's no rule that says you must only have one private session. I've had mediations where I've had, almost becomes a shuttle mediation because you have so many different private sessions. The other thing is that if there is anything said in private session, then make it clear to both the parties during your own opening statement that whatever is said to you during that private session remains confidential between you and that party alone. But it does provide you with an opportunity to reality test that party's commitment to settling the matter during a private session. But be careful not to call them in an open setting. Otherwise, you run the risk of alienating the party and appearing to be biased. Okay, well, thank you for those contributions. So they're really just some words. Josh said, make a statement that has nothing to do with the mediation to see if they clue on. Okay, so that's a left field sort of thought in terms of identifying something, and might be just a way of creating some sort of connection so that you get things started. All right, so there are a whole lot of other different factors that may be relevant to communication and conflict. In his text, David Spencer has some excellent commentary in relation to reframing. I'd ask you to read that carefully because that's a skill that you need to practice. And I think I do this every year. I encourage parties to practice their reframing skills and their body language skills at home. Now, you don't want to get caught out with this, but how do I describe this? And I might seek some thoughts from the floor on this one. But I think we all know that body language, I'll start with body language and then I'll talk about reframing. But I think we all know that body language can create either impediments or encouragement to communication. So if now I go back from the screen, fold my arms, look around and look disinterested, then I'm probably not going to engage with you as much as might otherwise be the case. Particularly if I change the tone of my voice or start to fidget, because it just means, you're not really trying. Alternatively, if you move into the screen, if you show some positive body language, if you maintain eye contact, maybe change the tone of your voice, maybe a little bit more inflection, people start to engage and they're going to be more interested in what you have to say. And you're really dragging them in. You're saying, come on, look at me, let's focus, and let's see if we can work something out here. So body language is important. So the exercise that I want you to do is just during the week, think about body language and think about, can I encourage them to talk and open up a bit? Or conversely, can I discourage them to do it? And just play that little game. I'm sorry, I feel terrible always asking you to do this, but you really need to practice it and just watch out for the responses and think, okay, now I'm being effective here. I can see this. The other party is really responding to this well. That's a technique that works. This is a technique that doesn't work. So that's one thing, body language. The other thing is the type of question that you ask. And people enjoy someone who takes an interest in them. So it's not just the body language, but it's also the way you ask the question and try and encourage a response. That's important in a mediation session because you need to get things flowing, particularly if you've got a really bad one where you've got two parties who are in an entrenched position and they don't want to talk to each other, so you need to develop these skills. Are there any questions or comments about that exercise that I'm going to ask you, that I'm asking you to do? All good? Okay.
I'm not sure what what the exercise is. Can you be more specific as to what we need to do?
Yep. So this is not something that's going to be tested, other than perhaps it may come through in the assessment. But the exercise is to use your body language skills and your skills in asking a question to encourage people to engage in conversation with you. Now, and it's it's really an exercise in, say, in body language. If you're involved in a discussion, just gently use a few techniques and see what happens. See how the other party responds. So if you're involved in a discussion with your partner and you just show some real interest and you move forward and use all those open techniques, and you might just get a really good response. You say, oh, he or she really does care. Oh, this is great. And open up, and you'll see it. You'll see the response. And you think, okay, this is the sort of thing that I can use in an ADR session to get people more engaged. And then you could gently try the other thing as well, sitting back. Hand to the face is a real negative. People don't like that. And just see what sort of response you get, and you'll see people switch off and they'll look away. They're not interested. Okay, so that hopefully that's the explain the exercise, Gordon. It's just really meant for you to practice some of your skills in a proper way, in a more physical way. Does that answer your question?
Yes, but I won't do it with my wife.
Yes, Jason?
Okay, so moving forward, we're obviously going to try this initially on our partners. Now, should this go belly up, do you accept liability? Can I say, no, this is an exercise and John has requested we do this to get myself out of jail?
You can, Jason. You can encourage your partner to contact me and I will apologise for having set such a terrible assessment. You can dob me in. There's no problem with that at all. Molly, you have a question?
Yes, I was just wondering, how far would you say would be, disrespectful or rude? Like, say, sighing in the middle of somebody talking. Is that would, to me, seems to be a bit too far. So how far would you say go?
I would suggest, for everyone's safety, be subtle. But all you need to do is be subtle, and it doesn't take much of a difference. But see if you notice it. I guess the exercise is more in terms of the positive side of things rather than the negative, because that's the sort of thing you'll use in a mediation session. Although sometimes you do use a negative as a positive in an ADR session, if that makes any sense. And the one that I'm thinking of particularly is silence. And I'll say that, and you might even practice this during a conversation or a discussion. Silence is a very valuable way of encouraging people to speak, because people don't like a vacuum. So if during a mediation or conciliation session you find that you're just not getting people to make offers at that critical time where you think, come on guys, make some offers to each other, one thing you can do is just stop, remain attentive, but remain silent. And you'd be surprised how many times people think, okay, well, subconsciously, that's my cue. And then they talk to each other, use the language, talk to each other, and that's when they might start to make an offer. So, Molly, to answer your question, we'll try and be subtle about it. Try not to get into too much trouble. Michelle says playing with strangers seems like so much more fun. Yeah, that may be the case. All right. Thank you for that. The other thing too is, practice using open and closed questions while you're speaking with people. Consciously think about it and think, okay, this is I'm asking an open question now. That's the sort of technique that we use in an ADR session, as opposed to I'm asking a closed question now. We don't really like closed questions when we're a mediator or a conciliator. Can anyone tell me the difference between an open question and a closed question, and can you tell me why we like open questions and why we don't like closed questions?
Okay.
Yes, Michelle?
It's because when you ask a closed question, you basically get a one-word answer, which cuts off communication.
Exactly. As opposed to an open question, which encourages communication. And thank you. Just when it comes to core technique, when I'm involved in cross-examining someone, I try to ask closed questions, but do so carefully, only if I'm ready to ask the next question quickly, because nothing is worse for someone who's doing some cross-examination work than to ask a long question and then have a response of no before you're ready to move on. So in that way, you've got to be thinking about things as well. So the same applies to an ADR session. Just be ready, hopefully have a few questions up your sleeve ready to go. Okay, so do you agree with me when I say that it's better to have an open question rather than a closed question? Just a thumbs up or thumbs down? Yeah? Open questions? All right, we're happy with that. So do practice that. Practice using silence. Practice active listening, which is a skill that you must have. These are all the things that I'm looking for when I'm assessing a mediation, by the way. Try practicing your sponging technique. We talked about sponging before, which is where people are really getting aggravated and they're at each other, and you're drawing it all in and sort of taking the brunt, as it were, and let them get it off their chest. So you may have that in your sessions. All right, well, I'm sorry it's been a bit lengthy tonight. If I could just do a little bit more. When you're reading Spencer, you'll see that there are some attributes of negotiation, which are essentially the advantages of negotiation. And the negotiation process is outlined very well and follows a typical mediation or conciliation session. So I will leave you on this unless you've got any questions. But negotiation is successful, says Spencer, when the participants are able to, firstly, undertake some preparatory steps. As a mediator, you want people to come in with some advanced thoughts. So if you're involved in an intake session, I think you should be encouraging the parties to identify the main points of dispute, which means identifying the main facts that are relevant to the matter and identifying essentially what the parties agree upon that's important and what the parties disagree upon. So during that intake, you're encouraging the parties to take some preparatory steps so they're thinking something that is important and something that is relevant. So that's the first thing that Spencer says. Second is establish authority to bind. Well, you need to do that during the opening statement. Make sure that the people that are there have authority to make a binding decision, which I'm sure you'll do. And then the third thing, this is all part of negotiation, but it's really similar to conciliation and arbitration. The third thing is identify the issues. What are the real issues of importance here? And you have to be careful with this, because one of the horrible things for a mediator or a conciliator is that you're 2 and a bit hours into it, and then one of the parties raises a new issue, which is not part of the agenda, not part of the opening statements, and it just throws everything out. So you've really got to try and identify those issues, the key issues, to create the agenda at an early stage. Okay, the next part of negotiation, says Spencer, is developing options, and that's really important, so that and that's one of the big advantages of mediation or conciliation, that you can encourage parties to consider options, consider alternatives, negotiate in good faith towards an agreement, then document the agreement and act upon it to conclude all matters of mutual concern. I'll leave you to read for yourself the different models of negotiation: adversarial, integrative, distributive, or principled. And when you're reading principled negotiation, think about juror number 8 in 12 Angry Men. Have we all seen that movie? If you haven't, please do so. I think I've created a link for it on the front page of Moodle. I think it's still there, unless I took it away. Has anyone seen it? I like the 1957 version. Gordon has? Yep. So Michelle has as well. Have a look at it and look at the star of the show. Ricky enjoyed it. Jason says the way they talked to each other in 1957. Melissa sent it as well. Yep. So for those of you that are watching this after the event, I'd encourage you to do that. Now, Ricky's asked a question. Do we have a tute next week, the 18th? I believe it's a break week, so we don't. To answer the question, but I'll put something on there as well on Moodle. Okay, so thank you very much for participating tonight. Before I stop recording, are there any questions, comments?
I have a question.
Yes, Molly?
You were talking about how open-ended questions are better. I was just thinking about reframing in particular. Every time I think of reframing, it's always closed-ended questions. Is that still okay, or do we need to work on making them more open-ended?
I think the best way to reframe is to both detoxify and redirect. So in terms of reframing, we might be stripping away the emotion and the nastiness and reframing that sometimes as a new topic or a new statement. So it might be something like, so you're concerned about the way he always leaves his room untidy and you'd like to see something done about that. So what do you think the options are for keeping a tidy household? So you're stripping it, you're acknowledging it, you're reframing it, and then you're opening it up again. Sometimes the questions can be a bit long, but I hope that answers your question, Molly. Any other questions, comments? All right. Well, I'll end the recording now, and thank you for joining us. We'll see you in 2 weeks.